Court, all rise. Hey, all present before the Honorable Justice of the Appeals Court now sitting in off the bar within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning. Good morning. Welcome to the Appeals Court. Let me introduce the panel. To my right is Justice Ditkoff. To my left is Justice Tan, and I am Justice Shin. We will be your panel for all 6 cases today. As many of you know, the rules of oral argument are that each side has 15 minutes to argue. When the yellow light goes on, you should think about starting to wrap up, and when the red light goes on, it means your time has expired. And for better or for worse, we do not allow rebuttal in the Appeals Court. You can be assured that the panel has read your briefs carefully and we're familiar with the record, so my best advice would be to get to the heart of your argument. And the last thing I will say is that these proceedings are being streamed and recorded, so if you're sitting in the center section, the camera will pick you up. So please be aware that if you do not want to appear on the camera, and I'm thinking in particular of any party who's here on an impounded case. All right, with that, I will call the first case, which is, you're going to have to correct my pronunciation, Commonwealth versus
DEIVISSON, GOULART.
DEIVISSON, LOPES, VIEIRA, GOULART.
Right, yes.
Case number 2025P396.
Good morning, Your Honors. My name is Attorney Carl Suchecki, and I represent Mr. GOULART today. What we have here today, Your Honors, is the judge abusing his discretion on motions for a mistrial in the case. During the direct examination of the complainant said, was talking about some jokes that Mr. GOULART had, and he said, I kind of like, you know, he did it to anyone, any kid that it was around, it was just me, but takes the pants down and put it down like, you know. And so it was essentially saying that Mr. GOULART would sexually assault him. Trial counsel objected to it and went to a sidebar, and the judge asked about it and agreed to do a curative instruction. So after sidebar, the defense pointed out that this was the subject of the motion in limine, and that should not have come in. So the judge tries to give a curative instruction. So the court says, all right, when they call back, rather than keep you, so he's talking to the jury, while I discuss legal issues with the lawyers, we'll take a break. But first, I told you on occasion I might strike testimony. And then he states, the last question and answer are stricken from the record. And let me just explain why. And that means you can't consider them. And then he says, there are no contentions, no allegations of any sort involving any persons other than this witness.
Whoa, hold on. You can't say the name of a...
I apologize, Your Honor. Then the complainant, the witness. And then the witness says, there is, yes, there is. And then defense counsel objects. Then actually the court gets flummoxed and says, oh, if you could just let me finish, that there's no evidence in that regard, so when that's the case, I'm going to tell you to strike that testimony. What we'll do now is take a break. So then the jury is out, and the jury goes out for 30 minutes. But what's happened is, that's the curative instruction for the pants. The judge tried to give a curative instruction. Defense counsel says there ought to be a mistrial just for the pants incident. But the judge, when the complainant blurts out, there is, yes, there is, that never gets contradicted. So the judge lets that sit. Then the jury goes out. They're out for 30 minutes. Nothing is said about...
When they come back, right, after the break,
back.
the judge repeats the instruction again.
The instruction regarding the pants.
Right.
Regarding the pants. Nothing is ever said.
But the judge also goes on to say, though, right, after the break, when he repeats the instruction again, he then says, stay focused on what needs to be decided in this case. There are no charges, no accusations concerning anything other than what you're going to hear from the victim and defendant, and there's no evidence in that regard either, right?
But the judge makes no mention of the interruption. And the defense counsel asked for a motion for new trial because mistrial, based on the fact that the complainant directly is challenging the authority of the judge, in interrupting and contradicting the judge mid-curative instruction, and nothing is ever said about it. So then the jury's left with that. For 30 minutes, they go out. So they get to sit with that. That's the last thing they get from the jury, right, from the complainant. And the judge goes back, and when the judge comes back, the defense counsel says, well, you need to admonish the witness, the complainant for interrupting, and the judge refuses to do so.
So why would the victim's interrupting the judge enhance her credibility rather than hurt it with the jury?
Why would it enhance? She's literally contradicting the judge. When the judge says there's no evidence,
Right, so why wouldn't that make the jury think that she's less credible if she's showing disrespect to the judge and interrupting him?
I don't think they'll see it as disrespect at all. In fact, what the judge does when he comes back doesn't say anything as far as admonishing for the interruption, which he actually shows kind of extreme deference. He says that he kind of apologizes for interrupting the complainant when the complainant said, yes, there is. The complainant was not allowed to testify. This is the exact propensity type of evidence that is not allowed. There's no evidence of that. But by saying that, the pants thing, which should have been a mistrial granted because that's evidence of other allegations of presumed sexual misconduct, but saying there is, that means that in the way the judge phrased his curative instruction, it implied, and if you read it, it almost implies that there are allegations, but you're only to focus on what's here. And the judge does nothing to contradict that statement. I don't see how it could possibly be negative for the defendant. The defendant for the complainant enhance her credibility by saying that she has knowledge that the jury doesn't know, and by the way, this knowledge is not being given to you, and then the judge lets it sit.
So, considering that the defense is that she's lying, she's making everything up, how likely is it that the jury would disbelieve the rape allegations but believe this claim that he pulls down everyone's pants?
You're going on that presumption that they're following the defense case and the defense.
Well, I mean, so since the defense is that she's lying, it seems to me there's only prejudice if they believe this claim that he pulls down everyone's pants. If they disbelieve her, it helps the defense case. So when you have a case where the jury winds up believing the victim, where do we find the prejudice when the whole claim was she's a liar?
I don't think that you can't just wipe it and pretend this didn't happen. You can't pretend that there's a direct challenge to the authority of the judge where the complainant is literally saying there's evidence of other allegations. And it goes, all the cases that the Commonwealth cites has to do with the pants thing, but there's nothing said by anybody. And this panel and the judge can't just pretend that it didn't happen. Those words are out there floating there. And just by pretending that, oh, it's for the defense case, that statement was made in open court to the jury. The jury was there and listening to it, uncontroverted anywhere. He doesn't say, you're not to interrupt me. He says, the judge just plows right through and does the quote-unquote curative instruction. And then afterwards, he apologizes to the complainant for interrupting and says, oh, we work out things between us as lawyers and not to be too confused, but try to stay focused, which is kind of placating the complainant, which says nothing about the taint of the propensity evidence that was said with no contradiction.
The jury acquitted on one count, correct?
Right, but that could have been played out. It has nothing, just because the jury acquitted on one, they could have acquitted on all three if perhaps they didn't have the taint of this evidence. You can't just pretend just because one count is pled out.
It's not pretending, right? It's sort of going to your argument.
It's a fiction. It's a fiction to say that this wasn't controversial or it didn't taint the trial. I mean, you can't. The judge pretended that it didn't happen, and you can't sit here and not read this transcript and how the judge tried to cure it, and then his curation after the outburst, no mention of it. And the trial counsel is like, you can't unring that bell. It's true, it's out there. So the jury is sitting with this information, and they come back and there's nothing said about it? I mean, it just sits there, it's in the ether, and it's like, you cannot, it's not something that is a clear, in this particular case, is clearly abuse of discretion, because weighing all relevant factors, it falls outside a range of reasonable alternatives. It's improper first to say other kids experience the same thing, that's the first taint, and the misconduct of propensity, that they gave the jury that my client was a serial predator, and it's uncontroverted, and that there's other evidence out there. And the way the judge does a curative instruction implies that there's other cases, but just focus on this case, that other stuff shouldn't bother you. But the jury heard it. The jury wasn't cured. And it's not just one, they heard the pants thing, and then they heard, yes, there is, very adamantly challenging the authority of the judge. And the judge says nothing about it, absolutely nothing.
Can we talk about the impoundment? The disposition that you want impounded in the appeals court is still public in the Superior Court. Do you have an intention, or are you trying to do something about that?
No, I don't have. I've thoughts about the impoundment and the not guilties and all that, the other stuff in terms of how it's been now playing out. But in terms of impounding this particular case, the motion in limine had stuff that we don't think should be public record, and it was deliberately not. It was impounded for that reason, and we filed a letter explaining our reasons for impounding it, as did the Commonwealth.
So you're not seeking the impoundment based on the disposition anymore, just on the motion limine?
No, we're basing the impoundment on the entire case based on the prejudicial effect to my client. That this particular information regarding is part and parcel of the entire case. So if you're talking about the motion in limine and the like, that's privileged information, and that should not come out to the public.
All right, well, so are you still seeking impoundment based on Section 100C, or is it on other factors at this point?
I don't know what section that
Chapter
is, Your
100C
Honor,
is what says that acquittals are impounded, are sealed.
Oh, if it's acquittal, you can do anything you want. I mean, I'd be happy to have an acquittal, but I don't know. I just think that
Okay.
it's privileged information as far as the prior bad acts, and the reason this case is so inflammatory, the reason this should be overturned, is that this is propensity evidence that should not have come into the trial, and the first part shouldn't have come into the trial, and this idea that somehow yes, there is somehow you can wish it away, or the trial judge can pretend it didn't happen and just ignore it, but you can't ignore it. Mr. Goulart's constitutional rights were violated. This stuff should not have come in. It tainted the jury. The jury left with the impression that he is a serial predator, uncontroverted. The judge plowed right through. It showed the complainant overabundance of being nice for interrupting and being disrespectful to the court. So based on all the things that I've said and what's written in the brief, we believe Mr. Goulart deserves a new trial, and that it should be remanded for a new trial because his trial was unfair and it was prejudicial, and that evidence should not have come in. Thank you, Your Honors.
Okay, thanks very much.
Good morning, Your Honors. May it please the Court, ADA Ryan McCrory of Middlesex for the Commonwealth. The judge properly exercised his discretion in relying on curative instructions rather than granting a mistrial in this case. When a party seeks a mistrial based on the jury's exposure to inadmissible evidence, a trial judge may instead rely on curative instructions to correct any error and remedy any prejudice to the defendant. None of the circumstances in this case alter that basic rule or render the judge's decision to forego a mistrial and instead rely on curative instructions here an abuse of discretion. That remains the case. even where the witness repeats inadmissible evidence and even where the inadmissible evidence relates to sexual misconduct with children. And then none of the comments at issue here were so prejudicial that a mistrial was required.
Well, the instructions of the judge were he struck the question and answer, but then do you agree that he actually didn't specifically address the interruption?
No, I disagree with that, Your Honor. The interruption came after the judge says there are no contentions, no allegations of any sort involving any persons other than the victim, this witness. The witness then interjects, there is, yes, there is.
And did the judge then later specifically address that? I mean, I think the opposing counsel is saying no, right?
Well, again, I would disagree. The judge's second instruction is that there are no charges, no accusations, and no evidence of that in any regard. So, yes, I agree. The judge never said the words, I'm striking that. The judge clearly told the jury to disregard anything they had heard about there being other accusations against the defendant. And in Commonwealth v. Davis, the Rule 23 case I cite in my brief, it's a very similar factual scenario, and this court found that a similar instruction telling jurors to disregard other allegations against the defendant was the functional equivalent of striking the testimony at issue there. And I think the same should apply here. Telling the jury there are no other accusations or charges is the functional equivalent of striking that interruption. And on the subject of instructions, I would like to also point out that I do think the judge addressed the victim's behavior in that interruption. The judge instructed the victim, reminding her that trials are a very formal process. There are rules, and asking her going forward to try and remember those formal rules as she answers the questions. Yes, it was polite, but I think it was very clear and told the victim what was expected of her going forward and addressed the fact that she had previously interrupted him. And then, in weighing the prejudice here, I think it's important to take these comments in context. The jury heard far more inflammatory testimony about the charged offenses here. There was fairly detailed testimony about the oral and anal rapes at issue in this case. And the defendant, his main defense at trial was fabrication. And he argued in his closing that the jury should discredit the victim based in large part on her demeanor, pointing out that she had showed disrespect to the proceedings, she had not been following rules and orders about how to conduct herself. This interruption provided additional support for the main defense at trial. So I think that now on appeal, the defendant can't claim that that was prejudice that could have only been addressed through a mistrial, where it helped support his main defense. As to the fact that this statement was repeated, well, the defense cites to a number of cases in their brief where the court noted that there was no repetition of the statements and finding that trial judges did not abuse their discretion in failing to grant a mistrial. When the SJC was directly presented with a factual scenario like this, where there was a repetition of the same inadmissible testimony, they found that it was still within the trial judge's discretion to rely on curative instructions there rather than grant a mistrial, and that's Commonwealth v. Santana. And then, again, as to the idea that a mistrial is required in cases where the inadmissible evidence that comes in is related to sexual misconduct with children, this court has rejected that very argument in Commonwealth v. Silva. And I think it's notable in that case that the court drew a distinction between curative instructions and limiting instructions and noted that, well, in some cases, it might be warranted to have some skepticism about whether jurors can follow a limiting instruction given the mental gymnastics there. Those same concerns aren't present when we're dealing with curative instructions that merely tell the jurors to disregard certain evidence. And all of the cases that my brother relies on his brief on this point relate to limiting instructions, not curative instructions.
Well, I'm afraid you're going to have to talk about the impoundment now.
Okay.
So the disposition, that's the basis, I understand, of the Commonwealth impounding its brief, is public in the Superior Court. So what's the point of it being impounded here when it's publicly available from the Superior Court?
My understanding of 100C and JF is that sealing is automatic. After an acquittal, all the proceedings are...
That may be your position, but the Executive Office of the Trial Court is only automatically sealing things that came out after JF. And I checked this morning, and it's still public, the disposition is still publicly available in the Superior Court. So does that information change your view on whether your brief should be impounded?
I don't think so, Your Honor. I mean, my brief is written after JF. I think the sealing would still apply going forward. It doesn't change my position, no.
So you believe that every acquittal after 1983 needs to be impounded here, regardless of whether it's impounded in the trial court? Is that the Commonwealth's position? That's when the statute got changed to have automatic sealing. That's not what I've been experiencing from the Middlesex District Attorney's Office, but I mean, you don't have to do the same thing as all your colleagues.
Yeah.
All right.
I'm sorry, Your Honor, I don't have a great answer for you as to exactly the retroactivity there, how far it goes back. I would suggest that, given that what I have written and submitted happened after this acquittal, it is my understanding that the sealing of 100C would apply to my brief.
All right.
If Your Honors have no further questions, I'll rest on my brief.
Okay, thank you very much. The case is submitted. All right, the next case, I apologize for mispronouncing this name, is Commonwealth versus Nelson, HERINEO, GIRON, HERNANDEZ, case number 2025P831.
Good morning. Michelle Dame for Mr. Hernandez. May it please the court. The mother in this case testified to text messages she said she saw on her daughter's phone that were not authenticated. The text messages no longer existed, but the mother still had to offer confirming circumstances that the messages she testified about seeing were actually sent by Mr. Hernandez, and she failed to do so. Her daughter had previously testified that Mr. Hernandez had bought her phone, but only testified that he texted, "I love you." The mother went on to say that she saw text messages asking where her daughter was, to open the door for him, if she was sleeping, and that he missed her. The daughter, however, never testified that he would send her messages saying these things. The bar is not high.
Who else would send messages like whether the mother was sleeping and to open the door for him?
It could have been a boyfriend of hers. Any friend of hers her age who was trying to sneak into the house. There was no...
But the only person that we know for a fact snuck into the house is the defendant. So why isn't that a confirming circumstance? There's text messages on, open the door for me, is your mother sleeping? And then lo and behold, there he is having snuck into the house through the window. Why isn't that enough of a confirming circumstance?
That's not a confirming circumstance. There was no testimony about when these text messages were actually sent, if they were months or years before that incident that happened in October. So I don't think it wasn't like the specific, if that text message, if there was testimony that that text message had been sent 2 hours before Mr. Hernandez was caught in the daughter's bedroom, there would be more of an argument that that would be a confirming circumstance. But there wasn't any testimony suggesting that, and there was never any testimony from the daughter that Mr. Hernandez was the only one that had this number, that he was the only one that communicated with her on it. There was also no testimony that this was the number that the text messages were sent from, this was the contact name of the text messages, and the mother did not testify either as to what number or contact name these messages had come from.
So just to make sure I understand, do you agree that the part of the mother's testimony that she saw a text saying, "I love you," that the proper foundation for that was laid by the victim during her testimony? Would you agree with that?
Those messages did match up.
Okay, so you're challenging the other, what she described as text back and forth to find out where she was, if she was
Yes.
sleeping. Okay.
Yes.
Can you talk about why that created a substantial risk of a miscarriage of justice?
Because it corroborated an inappropriate relationship between the two parties. And it was amplified by the friend who also testified that she saw messages that seemed more sexual in nature than a fatherly love message on the cell phone. Now, the friend did not actually testify who specifically she had said those messages or what was specifically said, but the fair inference was that the friend had believed that those messages had also been sent by Mr. Hernandez. These messages were emphasized in the Commonwealth's closing argument, and they were used to corroborate the allegations and to corroborate that those messages showed an inappropriate relationship by saying that the mother could
Well,
see.
the only thing the prosecutor said was that he used the phone to communicate with her, including sending text messages. So, oh, I'm sorry. No, I'm misreading that. I'm incorrect.
Yes, the mother did, in closing argument, the prosecutor did say that the mother could see that the two had been texting inappropriately and that the friend had also seen those messages. So this was the reason that the Commonwealth wanted these text messages introduced, was in order to try to corroborate the inappropriate relationship between the two parties.
Well, he crawled through her window late at night, right, was seen on top of her, pinning her down. How would the brief testimony about the text messages cause any prejudice given that evidence?
Can I just add to that as well? There was also DNA evidence, correct?
Yeah, so for the
Matching
DNA evidence, there was also testimony that this was a sort of chaotic and disorganized household. So certainly the sheets that were taken from the bedroom a day or two after Mr. Hernandez was found in the room, no indication that those were the same sheets from that specific night or any other point. We don't know. There was a lot of people living in this house. Mr. Hernandez himself had lived in the house previously. And certainly with things being washed and, again, with the testimony from the friend also that this was, again, she had been at the house with the kids and that it was sort of a disorganized, chaotic, messy household that I think could go to counteract the DNA evidence in regards to the fact that he was in the bedroom that night. There was testimony that there was no actual sexual assault that occurred that night. There was nothing, there was no sexual assault observed by any witnesses that night. And these text messages claiming that they were being sent by Mr. Hernandez were like admissions of Mr. Hernandez of this inappropriate relationship. And again, without the confirming circumstances that he was actually the sender of those messages, it would have created a substantial risk.
How do we consider the fact that this was a jury waive trial?
It has some sort of impact, but again, the judge.
Do we presume that the judge knew that there wasn't an adequate foundation laid for these messages?
I don't think we can presume that, or the judge would not have allowed the text messages.
Well, there was
to
no
come in.
objection, right? So is the judge supposed to interrupt sua sponte and strike it sua sponte?
With it being a jury waive trial, he could have.
And you're saying that that's the error, that he should have interjected and struck the testimony?
I'm saying, well, without him doing that, we don't know whether those text messages were a factor in his decision in finding Mr. Hernandez guilty.
You're saying that there wasn't enough evidence for a reasonable fact finder to find that your client sent the messages, right?
Correct.
So why would we presume that the judge found that your client sent the text messages if a reasonable person couldn't find that?
Because we had two people that did not provide confirming circumstances saying that these messages were sent, or one definitively saying that they were sent by Mr. Hernandez, and one from her testimony where the logical inference was that she was saying that. If there are no further questions on that, I will briefly address issue 1 in my brief about the Commonwealth refreshing the memory of the first complaint witness. A witness's memory can be refreshed only upon a showing that their memory is exhausted or when they are unable to recall the subject of the questioning. It must be clear that that witness is experiencing a failure of memory and not just giving a response that the examiner did not expect. The mother here also testified as a first complaint witness, and she was asked if she had had a conversation with her daughter in the spring about the abuse before her and Mr. Hernandez had broken up. She testified that her daughter denied everything until the night that Mr. Hernandez had come through the window. This was unexpected, as the daughter had already testified that she had told her mother prior to that time of him coming through the window. The mother was then asked if she remembered having a conversation at the district attorney's office. She said she had, and then the Commonwealth attempted to impeach her, but the judge interrupted and said that it would be more effective to refresh her recollection. She was then shown a report that was made after that meeting at the district attorney's office. She said the report refreshed her recollection about what was said, but then again testified that her daughter told her in October about the abuse at the time that he had come through the window, not when they had broken up in the spring. There was a further exchange, because this was still not the answer that the Commonwealth had wanted, and the mother ended up saying that the conversation had taken place in the spring or the summer. She never said that she did not remember when her daughter had first told her about the abuse. She just testified to something that the Commonwealth was not expecting, something that was inconsistent with what she had previously told them and was inconsistent with what her daughter had already testified to. Her testimony initially was not confusing. She was specifically asked if she had that conversation in the spring. She said no, that it was later on, and then specifically said that it was October. So here, the Commonwealth was able to impeach their own witness without weighing the foundation necessary to do so, which is to ask if the prior statements were made and giving them a chance to explain them. But they also were able to use this to refresh her recollection, thus allowing those statements to come in substantively. Here, there was also a substantial risk of a miscarriage of justice because the credibility of the child was the crux of the case. First complaint testimony is allowed to help the fact finder assess the veracity of the allegations made by a complainant, and that includes the timing of when the first complaint was made. This allowed for the testimony concerning the timing to match up, thus enhancing the child's credibility. It was clearly important for the Commonwealth to get this testimony to match, or they would not have done so much effort in order to do so. And even though this was a jury-waived trial, it was the judge himself who actually suggested this line of questioning, so I would suggest that it would have had an impact on his findings. But if there are no questions on that issue, thank you.
Thank you.
Good morning. May it please the court, ADA David McGowan for the Commonwealth, asking this court to affirm this defendant's convictions. I'll start where my sister picked off on the refreshing and or impeaching dynamic over a series of pages. The important distinction from that clunky and maybe inartful back and forth between the witness, the prosecutor, and even the judge during this bench trial is that the statement prior to being presented with this report, the contents of which never made it to the fact finder, are consistent from before and they are consistent thereafter. Particularly before, the first complaint witness, the mother, indicated that the disclosure happened a couple of days before Halloween. That's at page 15 of volume 3, when the defendant came through the window, same page. The date that he came through the window is October the 13th from the responding officer in the second volume. And she indicated that she broke up with the defendant the previous spring, same page 16. When this refreshing and or impeaching happened, she was then asked again. The thing is, the situation happened around Halloween when she told me. The thing is, when the days went by, because you have to understand this was the same year, you understand what I'm trying to say? So spring is when we broke up. She had told me around October what happened because he came through the window. And so that's at page 18. So the statement, refreshed, and I believe that the ADA and the judge kind of observed that the witness was not refreshed. The consistent remains the testimony. The first complaint witness's testimony remains exactly the same. The contents
Except
of...
later
At the
on,
next
on
page.
page 19, she's asked again, so it's not your memory that in the spring or summer you had a conversation. This is after the defendant moved out, and she says it was after the defendant moved out in the spring, and agrees that that's when she had a conversation with the victim.
So looking at the victim's testimony and the first complaint's testimony, what that appears to be is conversations the mother had with her daughter. Did anything happen to you? What's going on? And the victim described that she did not tell the truth to her mother until later. And so that's the conversation. I think a fair reading of the testimony is that the first complaint witness, the mother, is describing there. I did speak with my daughter. In fact, it was the defense attorney who brought up that the timing of disclosure needed to be nailed down more, and that was at page 20 of volume 3, that he was frustrated that the timing wasn't happening. The testimony was not...
I don't know if I think, I mean, so at the end, and then we had that whole conversation about that, and then he came through the window. I mean, so by the end, the mother is now saying the conversation was before the window, which is what the victim testified to, but her original position, and you can understand why, because the victim says, I told my mother about abuse and she did nothing, and mom's saying, well, at first she's saying, no, nothing happened, I didn't know about it until the window thing, but then she switches to admitting that she knew before the window.
I'm not sure that's a fair reading of this chronology of the statements and the conversations, taking the victim's testimony and the first complaint's testimony side by side, particularly where my recollection of the victim's testimony is that she did not anchor the statement of when the timing of disclosure was really with any precision at all. And that I get that at volume 1, page 69. That wasn't, she wasn't offering that kind of specificity. And where the timing, as I read her testimony, where the timing of disclosure wasn't anchored, the inconsistency, or I would suggest consistency of the first complaint disclosure isn't really at issue, because timing isn't at issue in this case. The series of events from the initial criminal behavior on Christmas Eve to when the defendant moves out in the spring and then this climbing through the window in October, it's a pretty tight timeline from moving out in the spring and climbing through the window in October. The conversations occurred during that time. I believe what the first complaint mother is testifying is the conversations where she, lack of a better word, confronts her daughter, does not get the whole picture, and the mother is absolutely clear. I only get the full picture after he climbs through the window and this all blows up. And so while that might be what was going on, my read of the transcripts and how this evidence came in is that the timing of disclosure of the first complaint witness is specifically consistent from start to finish, and being shown a report from a trial prep session had absolutely no effect on making anything change or have more specificity at all. That kind of doves into the text messages, where the timing of these messages, the defendant buys a phone for the victim, he moves out, she explains the contact is consistent, he would come by from time to time and express his love for her. And my sister's absolutely right, there are some additional substance of those text messages that come through mom, and then the I love you is reiterated by the defendant's own statement on the night that he is confronted after climbing through the bedroom. I love you, but I love her. Now, the additional data points to those text messages There could have been a whole number of questions that would make a much firmer foundation to not have this be an issue on appeal. I do think the circumstances, particularly where the evidence itself was not verbatim quotes or screenshots or that, it's people's memory of what they saw, is corroborative by the entire context of the case, particularly where the victim testified first. That's why I think this takes the case away from the rubric in Conley where the officer saw a video and tried to explain video. Here, the victim described the dynamic and the regular communication, not with great specificity, but with enough to then, when the mother described the relationship and her jealousy of the continued communication, seeing those messages, I think the judge properly did not strike them sua sponte by finding it was properly authenticated, even if just could have been characterized as a close call. Even if that were error, not to introduce those extra portions of the mother's testimony, it is not important evidence in this case from beginning to end. And I'll go backwards in the chronology. During closing, the prosecutor mentioned this once in 9.5 pages of closing argument at page 73. Jessica told you that after that night, she made the victim show her phone the defendant gave her, and she could see that they had been texting during the period that he wasn't supposed to be in the house. The messages were inappropriate, and Kira told you about seeing those messages. That line is all based on properly admissible evidence. The inappropriate texting came in through the victim. The being there when he wasn't supposed to came in through both the victim and the first complaint witness mother, that the messages were inappropriate. The content, I love you, is obviously inappropriate. So everything that the prosecutor used in closing was based on sound, appropriate evidence, even if this court finds error in the extra descriptions that the first complaint witness provides here. And in particular, the strength of the case, if we took away all message of the text messages and we take away the timing of the disclosure from the first complaint testimony, you take away the two complained of buckets of evidence in this case, this evidence does not create a substantial risk of a miscarriage of justice where the first complaint testimony was clear with her testimony. It was corroborated by forensic evidence despite the passage of time. The defendant's DNA on her bed where she described a particular act that would have resulted in DNA being on her sheets taking place in that location. And when confronted, the defendant responds aggressively and complains to everybody, I love her. So these two buckets of evidence, I think, have no consequence to the trier of fact in this case, Judge Campo, and therefore there is simply no substantial risk of any kind in this case.
So with respect to the text specifically, the victim testified only about the I love you. Is that correct, or did I miss something?
That's my memory as well.
Okay. And that's not necessarily inappropriate, right?
In a different case, I think you're right, Your Honor. I think that no, in isolation, no. In the context of just having raped her and buying her phone for these communications, I think the context at that stage in her testimony when she describes it, yes, it's inappropriate.
So then there's no foundation for the mother's testimony that goes beyond just that text message, or for the friend's testimony that they were sexual in nature. What's the foundation for that?
It's thin, maybe gossamer. I don't want to, overreach with the factual record here. There could have been a number of questions, as I mentioned here, but I do think the context of how this testimony came in, it's corroborated circumstantially. And Conley is a great point of reference of what was trying to be introduced there, something a witness saw, but without any of the other circumstances that would lend the proponent of the evidence to support that it is what we're proposing it is. Here, the victim's testimony is extensive, describing the relationship with this individual, how it existed over text message, the mother knowing about it, confronting her about it, being jealous about it, and then what the mother saw and what the friend saw.
Do you think the friend's description of the text messages came in? I saw the judge sustain the objection after hearing the foundation.
Maybe not. It's an excellent point, Your Honor. I think some of the objections were not terribly clear throughout the trial, particularly where the objections, I believe, to the dates and the refreshing were more to...
That's sure true, but here the defendant said objection authentication, so...
Well,
it's kind
here
of...
for the friend.
It's
the
kind
friend
of funny because the objection came after the question, could you see who was sending Was there a name attributed to those messages, which actually would have laid the adequate foundation, right?
Correct. I think the challenge there and why that wasn't addressed more robustly is the number, that evidence was not available to the Commonwealth at the time of trial.
What evidence was it?
The number, the things, it wasn't able, if it was available, I would imagine it would have been introduced and that foundation laid. The phone was gone, the text messages were gone. This is all people's memory from earlier in time as to what they saw on this phone, which complicates things. It makes a piece of evidence that would otherwise be routinely admissible in the courts of the Commonwealth much challenging
Why
in this
couldn't
case.
the witness say, I saw the name attributed to those messages? Why would that be improper?
It would not have been improper.
Oh, okay.
I don't know if the witness could answer that in this context.
Okay.
So a routine example of admissibility in many courts of the Commonwealth and trials that are going on this week was a challenge in this case for reasons that the record doesn't speak to. Otherwise, they would have been addressed. But even the court raises great pause of what I think is a tough call if this were particularly a jury trial. But I do think the judge properly considered this. Even if this court finds that it was improperly considered, I don't think it comes within a country mile of a miscarriage of justice in this case, because the evidence does not move the needle in the face of the other much stronger, much more inculpatory and damning evidence, including the defendant's own admission when confronted, I love her.
Don't get many country miles in Suffolk County.
This was Chelsea, so yeah, the further reaches. But if the court has no further questions, thank you. I'd rest my brief.
Thank you. The case is submitted. Move on to case number 3, which is Commonwealth versus Edward Starling, Jr., number 2025P702.
May it please the court, Elizabeth Caddick for Edward Starling. This appeal of the denial of a 25B motion is very limited. The motion judge had committed 2 errors of law, each of which resulted in an abuse of discretion. The one error of law she made is that because the SJC had evaluated this case on direct appeal under 33E, that she was stopped from evaluating it under 25B2. That, in fact, is correct. Not only was the SJC's comments about its 33E review uninformative, it simply said that it reviewed it under 33E and found that there was no reason to disturb the verdict or reduce it. Certainly did not state that it was looking at it under whether the interest of justice deemed that it should be a lesser crime. It just used the boilerplate language. It said nothing more. But despite that, there's a difference between even that more gracious review under 33E and 25B, which is whether the current verdict is consonant with justice. And
What do you think the judge thought was estopped? Because the judge mentions estoppel, but considers the relationship to similar cases, talks about the voluntary intoxication issue that isn't being raised on appeal. So it wasn't clear to me what the judge thought was estopped.
well, in her decision, she begins by stating that the Commonwealth states that all the issues are estopped, and she agreed. So it seems to me she agrees that the arguments counsel made were stopped, but that she went on to decide some of the issues anyway, but still said for each of them, well, the SJC already evaluated this. So even what she did discuss was an abuse of discretion and erroneous. So for the issue of her ability to determine that there should be a lesser verdict because the evidence was weak, and because of that, the erroneous instructions on third-degree malice, or third-pronged malice, was prejudicial. And she stated that that was something that she didn't need to discuss. Now, so she didn't go through how the evidence was weak, because what she said was, well, the SJC said, the ME said, well, there could have been more than one blow. So the counsel in the motion stated that, as the SJC mentioned in Woodward, Starling's case is the only case where there was a single blow and no prior evidence of abuse. And the SJC said in Woodward, well, yes, but the ME said that there could have been more. Well, that's not evidence that there was more. It just could. I mean, even in Woodward, the Commonwealth's expert said, well, in their opinion, there was shaking, and then there was hitting the baby's head on a hard surface like the bathroom floor. So sure, there could have been two instances of more than one blow. So the fact that the evidence was weak in that the court and the SJC in Starling and Woodward made too much of stating that the ME said there could be. What the ME said was there's one laceration to the liver, and that was it, and that it could have resulted from a single blow or maybe more blows. Well, that's not evidence. What the evidence is, there was one injury. We know there was one blow. We don't know there was more. And so
Was there an injury to the child's mouth?
Oh, it was just superficial injuries that,
But
no
could.
one. Well, that was not testified to, and certainly.
What do you mean wasn't testified to? Dr. Atkins said there was a laceration on the lower lip, an abrasion on the lower lip, a bruise on the left side of the thorax, a contusion on the mid portion of the spine. Why doesn't those suggest not fatal blows, but other blows?
Well, because he did not find that they came about from something other than whatever the blow was to the abdomen. So that is certainly, there was no mention that was, there was no mention in the decision in Starling that those were evidence of additional blows. What the ME said was when he mentioned blows, it was to the abdomen. What he thought was, it was either a fist, a foot, or a piece of wood, but so the fact that someone was injured, a child was injured enough for those injuries, certainly, could have led to those other injuries contemporaneously. And so there was no additional evidence other than that one blow at that one time. And so with the faulty malice instructions, where the judge never said that in the circumstances known to Starling, a reasonable person would have known that it would have, the injuries would have led to a risk of death. So in this case, and again, we all know that you take the victim as you find them.
Right,
but
and here, right, the victim had a failure to thrive, was at 22 months, was 14 pounds, right, and almost half of what the normal 22-month-old would weigh, and was also quite smaller,
Yes.
right?
Right, and the ME on cross-examination conceded that what was called foot pounds, the amount of pressure to injure a malnourished child with weakened connective tissue was much less than would have been required for a healthy child. And would a reasonable person know that? So that's a reason that the evidence was weak, and with the faulty jury instructions, and the other evidence was that after the judge gave his confusing instructions, the jury came back and specifically asked for clear, they use the word clear, instructions on the difference between second-degree murder and manslaughter. And he did not give clear instructions. He even muddled the whole instructions additionally by talking about someone going down Washington Street speeding during Christmas and sees someone he knows and wants to hit him, or maybe just wants to touch him or scare him. It just was totally confusing. So in this case, the judge had...
I'm not quite following what's wrong with the instructions, other than they're very technical.
Oh, the judge's instructions?
Yeah.
Okay, well, he omitted that the instruction, which he was required to do, that the circumstances known to the defendant, he didn't mention anything about that the Commonwealth had to prove that in the circumstances known to the defendant, a reasonable person would have known that his actions were, likely to cause, substantial risk of death.
And what circumstances were there that the defendant wouldn't have known about, that the jury knew about?
Right. Well, one is that that doing whatever he did to the child was a strong likelihood that death would result, because if in fact he punched or kicked a 2-year-old.
Well, that's what the SJC rejected, that he had to subjectively know that it would create a plain and strong likelihood of death. He has to know the circumstances, but he doesn't have to know the consequences on that. That's objective, isn't it?
Well, I don't know that the SJC said that. It simply said that the instructions were wrong, but they weren't to the point where they were prejudicial. No one can actually, because he did not remember what happened, no one can actually say what he knew. And of course, the jury could have used their common sense to know what he knew, but they weren't told to do that. They weren't told to look at the evidence for third-pronged malice through the eyes of what he knew.
Well, were there any facts that the jury knew that he didn't?
Well, the facts the jury knew was how he behaved afterwards. They knew that there was no evidence beforehand of beatings, that in fact he was very kind and helpful to the child and babysat for her and took care of her medical condition. And I mean, they knew what he did afterwards, which was, ask the neighbor to call the police, try to track down the mother. Does that answer your question? I think that's all there was. And this case is not different from a lot of cases where there's only one person who could have done the injury, but it's unknown what exactly happened. But again, in this case, there's no evidence that there was more than one blow, just that there could, and that's not evidence that there was more than one blow. And as I said, both the SJC and the motion judge laid too much weight to that one could have. The judge also felt that she could not consider the fact that this was the only known case, where there was only, a single blow, but the third-pronged malice was found. And she cited to the Lyons case and analogized to that, but that analogy was erroneous because in that case, the SJC found that the father had shaken the infant for 20 seconds. And if you consider a blow, a single blow, 1 or 2 seconds, this was 20 seconds. And the SJC specifically said the baby would have been unconscious after a few seconds, and yet the father continued to shake the baby. And, that was the cause of the death. So for the motion judge to distinguish or to analogize Lyons to Mr. Starling's case was an abuse of discretion. So for those reasons.
Can I ask you about our standard of review? You say it's abuse of discretion, but in your brief you also say because the motion judge was not the trial judge, we don't owe her any deference. So which is it?
Well, there were 2 reasons I said. It was an abuse of discretion because she made an error of law and used that error of law to deny appropriate review. So
error of law is an abuse of discretion, but
yeah.
your first argument is that the judge abused her discretion by not reducing the verdict based on similar cases. That seems to be more of a discretionary issue than a legal issue. Are we reviewing for abuse of discretion?
Yes.
Okay.
You are, but and also, that you made an error of law, which is a stronger argument that you made an error of law.
Okay.
If there are no other questions,
Thanks very much.
Just, actually, just one, first of all, congratulations on the parole
Thank you.
decision you got. Has your client been released, or is he still looking for a
No, they're looking
facility?
they're looking for a nursing home, and it's very slow because the DOC just uses one nursing home at a time, and if there's no beds, if it's not appropriate, then they go to another one. So it's a lengthy process, but.
All right, I'm sure you're on top of it, though.
Yeah, I am.
Thank
He
you.
won't let me not be.
Thank you.
Thank you.
Good morning. May it please the court. Molly Paris on behalf of the Commonwealth asking this court to affirm the denial of the defendant's 25B2 motion. Here, Judge Ames was well within her discretion in upholding the verdict of second-degree murder. This is a case where the defendant has already received the benefit of a full 33E review. In conducting that 33E review, we know from the SJC's decision they expressly grappled with the issue of malice and the jury instructions. This case is, for that reason, wholly distinguishable from Pfeiffer, where in the defendant's direct appeal in that case of second-degree murder, there was no 33E review, and the SJC determined that the defendant's post-direct appeal 25B2 claims were not barred by estoppel. Even if the defendant's claims are not barred by estoppel here, the motion judge's decision was still within the range of reasonable alternatives.
It really is baffling to try to figure out what the judge did here, whether the judge relied on estoppel or exercised her discretion. I mean, can you help me with that? Because we can't really affirm or exercise a discretion if she didn't exercise it.
Yes, Your Honor. So I think while the decision could have been more clear, I think she addressed estoppel, and much like this court does, went on to still address the merits of the claims, did so explicitly as to 2 of the issues, and as to 2 of the other issues, addressed that in footnote 1 of her decision.
She did both, kind of a belt and suspenders.
She did both, much like this court often would say there's no substantial risk of a just like this court might say there's no error, but then explain why there's no error, or say the claims are waived, but we'll still address the merits.
So do you think that 33E review stops any 25B or only the 25B-esque arguments that were argued under 33? Is this making sense to you?
That makes sense.
Okay.
I think the case law isn't exactly clear on that point, but what I can say is in Pfeiffer, where the issue on direct appeal was sufficiency, that would suggest here where sufficiency was and malice was addressed in the defendant's 33E review, those claims would be later stopped short of newly discovered or newly available evidence. But I have yet to find a case to say unless those specific claims were raised pursuant to 33E. But again, on 33E, the court reviews the case raised and unraised claims. So I don't have a great answer for Your Honor, but I think based on Pfeiffer, the court can be assured, at least as to this case where the SJC grappled and addressed the issues of malice and expressly declined to reduce the verdict, that those claims now that are being challenged in his 25B2 motion related to malice and whether the evidence as to malice was slim have been addressed.
I mean, that makes sense, but not the similarity to other cases. I didn't see how that had been addressed before. Am I missing something?
No, I understand Your Honor's point, but what I would suggest is cases that came after Starling, his direct appeal in 1981, didn't create new law, such as Woodward. In fact, Starling has been affirmed indirectly in those decisions as to Woodward and to Lyons, Moran. And so I don't think that changes anything here.
Well, I mean, if your claim is it's unlike similar cases, and then there's a whole bunch of similar, I know this is not what necessarily happened here, but if you had someone who got convicted of murder too, and then there were a bunch of cases being dropped down to manslaughter afterwards for the same reason, wouldn't that be a sort of a new ground that you could raise to say, look, this is now dissimilar?
I think it would depend on the grounds that the defendant would be raising in his 25B2 motion. So here where he's saying in his 25B2 motion the verdict should be reduced to involuntary manslaughter based on evidence of malice being thin, I don't think any of those subsequent cases changes that. And again, where he's had that 33E review, it would seem like this court addressing that would just be to disturb the 33 review and finality. But even if this court were to determine that those claims were not stopped, the motion judge was well within her discretion in upholding the verdict.
So in your brief, you say that we're in as good a position as the motion judge to assess the defendant's claims because the motion judge was not the trial judge. So isn't that a little bit contradictory to then say that the standard is abuse of discretion?
I don't think so. I think it's much like review of a defendant's motion for a new trial without an evidentiary hearing where this court can review, the pleadings that were submitted and before the motion judge review the transcripts, all of that.
Right.
But
I don't find the case law to be perfectly consistent whether our review in that situation is for abuse of discretion. Do you have any cases that arise in this context, the Rule 25 context?
I don't have a specific case right now to offer you. I'm happy to do further research and submit a 16L. But from what I found, an appellate court's review of a judge's decision to reduce the verdict is reviewed for an abuse of discretion. But
So if the three members of this panel think, just hypothetically, oh yes, the cases cited by the defendant are similar, but reasonable minds can differ, so it would be within the range of reasonable alternatives for the judge to find otherwise. That would be how we would review the claim.
That's correct, because the question isn't whether this court would have decided differently. The question is whether the judge's decisions was within the range of reasonable alternatives. And what I can tell this court is that in my review of the case law, I have not found a case where this court or the SJC has found that it was an abuse of discretion not to reduce the verdict, which is what we have here.
I mean, the only case I found where you had a 25B motion that wasn't sufficiency, that was a different judge, was Rogers. Have you found any different one? That's the only one I could find. I looked for a while.
I don't have one off the top of my head, But I also think that speaks to the problems with 25B2 generally, of where the defendant here filed his 25B2 motion 40-something years later. So I don't have an exact case on point. But again, even moving on from estoppel, looking at what the judge did here, her decision was proper, where she applied the correct legal standard. She distinguished sufficiency of the evidence from whether a verdict is consonant with justice. And she also determined that Woodward, where the SJC affirmed a reduction in the verdict, was factually distinguishable from this case. Woodward was a case where the victim lived for 5 days after the injuries. There was conflicting evidence as to the medical evidence and the cause of injury. And significantly, unlike in Starling, he did not receive an involuntary manslaughter instruction. And the evidence here certainly warranted the finding of malice, where this victim sustained one or more severe blows to the abdomen or chest. Those blows were inflicted by a blunt force instrument. There was testimony as to that could have been a foot, a fist, or a board. And the fall was inconsistent with the defendant's statement to police as to falling off a bed or the victim being pat on the back. And again here, the motion judge also determined that this verdict was not markedly inconsistent with that in Lyons. And that's really the question in assessing whether a verdict is consonant with justice. The question for the motion judge is whether the verdict is markedly inconsistent, and here she found that it wasn't. Unless the court has any further questions, I'll rest on my brief.
Sandy, thank you very much. Thank you both. The case is submitted. Are there attorneys here on the fourth case? If so, we will proceed to the fourth case before we take our break. Okay. John Doe, number 528723 versus Sex Offender Registry Board, case number 2024P 1405. This case is impounded, so I'd remind counsel to please use pseudonyms or some other way to refer to the parties other than their names.
Good morning. May it please the court, Elizabeth Doherty for the plaintiff in this case. As this court knows, since 2010, sex offenders have had they've been statutorily entitled to a right to counsel. Since 2008, the sex offender registration law has been construed to grant the discretion to allow a motion for funds, even when the board wasn't going to have their own expert. So those two rights were very important in this case, and this plaintiff received ineffective assistance of counsel and didn't have an expert opinion that could be counted in this case because of the deficient representation of his counsel.
It seemed to me that the report could be considered for everything but for the ultimate conclusion of low risk of reoffense. Isn't that what the regulation says?
Right. The ultimate risk opinion of the evaluation that came in was not accepted. The hearing examiner considered other material that was in that evaluation. But I would suggest that, and as the SORB counsel did point out at the Superior Court hearing, that opinion was, it was not admissible because there was not live expert testifying, so it wasn't admissible for that reason. But even in of itself, that opinion would not have addressed, it did not address because it was for a different reason. It was for an aid in sentencing in a criminal case, and I think also some sort of a competency as well. So that the opinion, had the opinion come in, it wasn't, or the ultimate opinion in the evaluation report, it didn't address the SORB factors, and it also, in this case, so it would have been deficient in that, or objectionable in that point. And frequently, as you'll see in SORB cases,
it may have been objectionable, but the examiner seemed to consider everything but the final conclusion. Didn't credit much of it, but
right.
wrestled with it at least.
But the opinion in Dr. Quirona's report, again, didn't address the SORB factors, which is very key in the opinion in this kind of a classification. In addition, had there been a motion for funds made, which I think there was a reasonable likelihood, had a proper motion for funds been made, it would have been granted. There could have been a forensic psychologist or some sort of evaluator that could have addressed the factors of emerging adults and that.
Right, but so what would a expert who was retained have said that would have been helpful to your client?
Well, I think that, and I appended to the reply brief a recent Superior Court decision, which I know is not this court does not need to consider, but it may be considered persuasive. All of the kind of new research that's come out that would have gone to the risk of reoffense and dangerousness could have been addressed. All the Mattis factors that.
But you're bringing this on an ineffective assistance claim.
Yes.
Which requires you to show prejudice. So I read your reply brief to be saying the prejudice inquiry is whether the motion for funds, there's a reasonable probability that the motion for funds would have been allowed. I'm not sure that's the right formulation as opposed to, is there a reasonable probability that the classification would have been affected?
I think you're right, Your Honor.
Okay,
that in fact.
So you agree the prejudice inquiry is whether there's a reasonable probability it would have changed the hearing examiner's ultimate conclusion? Do you agree with that? Okay.
I do.
So then my next question is, without having any evidence in this record about what the opinion, had he requested funds, had he been granted funds and gotten an expert, if we don't know what the opinion would have said, how do we determine prejudice?
Of course, we don't know. I mean, only had a motion for funds had been crafted and allowed, and then an opinion. And I certainly can't, as the trial counsel noted, I certainly can't assert with complete certainty that had an opinion gone in that that there would have been a lower classification level. Because again, yes, we don't know we don't have an opinion.
So doesn't that defeat your claim on direct appeal?
Well, I think that the prejudice that's here is that he was basically, to use some of the language from he was denuded of a defense. It's clear that the hearing counsel depended completely on an opinion. Now,
But in a criminal case, you'd have to show up with a new expert like they did in Millian and have that expert explain what their opinion would have been, and then the court can adjudicate whether that would have made a difference to the jury. So why isn't the fact that we don't know what an expert would say, if there even is an expert who could say something helpful, why isn't that a problem?
Well, I have to acknowledge, I mean, it is a problem in that in the appellate situation, I mean, we're sort of left with the record that there was. And I need to point to, in terms of how an expert would have made a difference, somewhat generic cases like Doe 89-230, where they talk about how experts, not in particular, but in general, experts tend to have, they improve the chances of getting a more favorable disposition. But then also, I would point to the fact that this particular person was an emerging adult through all of his offenses. They took place through 16 through 19. And that 19 is right in the smack of being an emerging adult, and an opinion on that would have been helpful in this.
But don't we need some evidence to support I mean, I understand your argument,
Yes.
but.
Well, I think that there, and this kind of goes back to that it was ineffective. I think in the Dr. Keone's report, although it could have been, a better report would have been more tailored to the SORB factors. There were a number of parts in her report that were helpful, talking about how the sort of age crime curve and how, as you know, with maturation, that the risk of reoffense and the dangerousness.
Wasn't your offender still an emerging adult at the time of classification? He was 21?
He was 21, yes.
So why wouldn't an expert say, because he's still an emerging adult who hasn't matured yet, that his risk of reoffense is quite high, though it will drop when he turns 25 or 26?
Well, I mean, I think practically in this case, so what you have in this case is his last offense was at age 19. He had been then in the community for that period of time from 2021 and had not reoffended, which tends to, I mean, certainly he could reoffend after that, but at that point there was some real life evidence to show that he was exemplifying that he was not.
But that seems contrary to the theory that emerging adults haven't matured, if you're telling us he matured while as an emerging adult. Is there an expert that would have said that?
Well, I don't know. I mean, as I say, I think Dr. Keonis in her report suggested that, you know, that he was already showing some signs of maturation. You know, in addition to this, I did point to the emerging adults, and I did rely heavily, obviously, on the recent Superior Court case showing the kinds of things that could be produced in that. He also had, I think the report suggested he also had some intellectual deficits and whatever. And
the complicating factor here is that it's being brought as an ineffective assistance claim. And in the criminal context, we've said the favored route is not to bring these claims on direct appeal, but to file a motion for new trial. What is the mechanism for filing a motion before the SORB on an ineffective? Can you move to reopen a SORB proceeding based on ineffective assistance?
I think so.
You can?
I want to say that it's Rule 60B under the rules of civil procedure.
So your client could go back to the board and say, reopen my original hearing because my counsel was ineffective for not requesting funds, and here's what I would have presented. Here's what an expert would have said and made a proffer. He would be able to do that?
Well, I don't know whether he would, in that context, he would be able to get, now this client, this individual was adjudicated to be indigent. I'm not sure in that context that he would be able to get funds to.
No, I'm just asking as a procedural matter, does he have available to him some mechanism to reopen the proceeding based on ineffective assistance?
Under that proceeding, I think he does.
Okay. And
I'm not sure. I'm not
he's up
sure
for
whether there's in the civil context now. I'm sort of thinking ahead of like waiver type things, and that I'm not sure about.
You're not sure about what?
I think there is the ability to reopen it
Okay.
under 60B.
All right. So he's up for reclassification this summer?
I believe that's correct.
So if this case is ongoing, let's say there's a motion to reopen, he would not be able to move for reclassification. Is that correct?
He doesn't. I guess he does not have a he doesn't have a final determination at this point.
So he would not be able
Yes.
to proceed
Yes.
on both routes.
Yes.
Okay.
These were some of the variety of options that we discussed at the beginning of this case.
So you mentioned a waiver. I suspect, because opposing counsel did mention this in her brief and you addressed it as well, waiver. Can you talk about that? Because I suspect that she's going to stand up and say this argument was waived because it wasn't raised.
Yes, and I think that, I guess, she's going to talk about a different kind of waiver that I'm worried about, but certainly. The board argues that this court should not consider that because it was not brought up below. And so I can address the two areas. It was not brought up at the administrative hearing because, citing to Commonwealth versus GIRON, the council cannot be thought to bring up their own.
Sure.
So I think it's not waived at the
But superior.
at the excuse me, at the Superior Court level, I believe the record that is of the Superior Court hearing establishes that trial counsel did bring this up, that did bring up, perhaps not exactly in the way that I have, but did have enough that this was ineffective assistance of counsel, that there was prejudice because there was not an expert. So I think that's sufficient for this court to be able to address that. And I think some of the cases that I've cited in my reply brief, that there's a sufficient record.
Your predecessor certainly raised ineffectiveness, but it was based on the closing argument and failure to call Dr. Quinones, right? That was the arguments made in the memo?
At the Superior Court stage?
Yeah.
Yes. I mean, I think that there was not an expert opinion. As they say, I think that's sufficient for this court to be on notice and have.
So by failing to call as a live witness the expert engaged on behalf of the plaintiff. So it seemed like the memo was saying Dr. Quinones specifically. Am I misreading
that? Was, but I mean, I think that that was adequate for this court to address that that opinion. Not only was there not a live opinion, but it wasn't an opinion that was tailored to the SORB factors for that.
Well, on the first page of the judge's decision, he says Doe's claim is that his counsel's failure to have an expert testify in person constituted ineffective assistance. So that suggests to me that the claim is not limited to just Dr. Quinones.
I think that's right. I mean, what trial counsel was looking for was for this to be remanded for another hearing where an expert could be there. And trial counsel himself said, I don't know, that will ultimately provide a lower classification. But I think that coming back to the denial of effective assistance of counsel, he was denied a fair chance. He was denied a chance for a fair and accurate determination of his classification level.
Okay, we'll have to leave it there. Your time has
There were no
expired.
other
Thanks
questions.
very much.
Thank you.
Good morning. Jessica Blackman on behalf of SORB. I think you know where I'm going to begin with this, starting with waiver. I do think that there's two very distinct issues with regards to the request that was made. Doe's argument at the Superior Court was that there was a failure to file funds for the expert that was retained previously. I think you can read into that would be Dr. Quinones. Her report was submitted into evidence. Everything in that report, aside from any risk opinion, was also considered. That would be, the issue that was raised at the lower court.
Well, the judge said the claim was the failure to have an expert testify, right? So he's indigent. So in order to have an expert testify, you'd have to request funds. So why isn't the claim fairly encapsulated in the claim you raised below? That's my first question. My second question is, do you have a case that says that a failure to raise an argument in a 30A before the Superior Court results in waiver on appeal? Because the cases the SORB continually cites have to do with failure to raise a claim at the administrative level.
So there's two. Let me see, yeah. So Carey versus New England, I think
That's summary judgment. I'm talking about a 30A appeal, because 30A is unusual in that it's essentially 2 bites at judicial review, right? First in the Superior Court, and then in the Appeals Court where we review de novo. So I have not seen a SORB case that says, or a 30A case for that matter, that says failure to raise in the Superior Court results in waiver on appeal.
Well, I think where it says that the board has not been given the opportunity.
Right, no, we get the idea about things not being raised at the board. But the question is, why does it matter what got raised at the Superior Court? I mean, I don't even know why we go to Superior Court at all on these things when it's just de novo review by the Appeals Court. I get, like, stuff you haven't raised in the
I think it's the opportunity for the board to
is
defend
different.
the action.
But you have the opportunity here.
Yeah.
Right.
Well, and going through when counsel was asked about whether to reopen the record, I think that's where that would happen. It would be a remand where the lower court finds that something was.
The board, right?
What?
The board, not the lower court. You said the lower court.
Well, when you were asking to, I think the opportunity to get that record reopened is when the Superior, when it's brought up at the Superior Court level and they remand it. That's where they show that something hasn't been done correctly and it needs to be remanded and reopened. And
Remand to the board.
Yes.
Is there a mechanism for an offender to move to reopen a board proceeding based on ineffective assistance?
Not that I'm aware of.
So
or
how
at
would
least
you
not that I
ever,
have.
how would an offender ever be able to raise ineffective assistance if the offender needs evidence in support of the claim? What's the procedural mechanism? In criminal context, you file a motion for new trial, right?
Okay.
In the SORB context, what do you do?
I mean, there's an opportunity, they can ask to reopen the record if there's substantial evidence that didn't get put in. I don't have an answer directly on the point of ineffective assistance of counsel.
I mean, the problem we have is there's an opinion out of our court, DOE 27914, which says that you've got to go raise your ineffectiveness claim at SORB. And if there's no way to do that, then we have a problem. I mean, we have a problem, not you, but we do.
Yeah, I apologize. I don't have an answer directly on point for that.
Can it be raised as an alleged procedural irregularity in a 30A case before the Superior Court?
My understanding is that's where you would, just like in this case, that's where it would be raised, that something was missed, that something was done incorrectly.
And that would encompass, in your view, ineffective assistance, a procedural irregularity not shown on the record would encompass ineffective assistance?
I mean, that's literally what they did in this case. They told the court that they didn't call as a live witness.
No, that's not what they did. So I'm talking about the provision of Rule 30A that says you can get a hearing in the Superior Court for alleged procedural irregularities not shown on the record. But I'm not sure if a procedural irregularity encompasses ineffective assistance. Do you have any position on that? As Justice Ditkoff said, there has to be a mechanism to raise this, or else we have a problem.
There's got to be one somewhere. We just have to figure out where.
Yeah, I honestly do not have an answer. I mean, I still think it's something that would be raised in the Superior Court, whether on the record or not. Just like here, what was missing was expert testimony, and that's what they're saying, is the counsel procedurally didn't do something correctly, just like raising an objection that they feel was incorrect and, not taking in something to the record or not admitting evidence into the record. I think it all falls under the 30A, as counsel did in this case, because this was not his, this was new counsel at the Superior Court level, separate and aside from counsel that represented him at his hearing. So he basically raised the same issue that's being raised now, except that in that case, at the Superior Court level, they're indicating that that witness that had provided the report that was submitted should have been called to testify. I think it's important to note that that witness would not have qualified as an expert in these cases.
That's something that really confuses me, because I read Factor 35, and it specifically says the board shall consider evaluative reports like this.
Correct.
And then it says, the ultimate risk opinion of the evaluator, if any, will be excluded from consideration unless the evaluator testifies as an expert witness at the classification hearing. So it seems to say in 35 that those evaluators can testify at the hearing.
If the report was produced specifically for use by a party at the hearing.
Well, that's not what 35 says. It says, shall consider evaluative reports, including but not limited to documented reports generated during sexually dangerous person proceedings, risk assessment reports completed for sentencing, probation or treatment planning, which would not be reports for a SORB proceeding. And it says the board shall consider those, and that person the evaluator has to testify in order for the ultimate opinion to be considered. So I don't know why that doesn't allow a doctor like Dr. Quinones to testify at these hearings. I understand that 117.5C seems to say differently, but that's problematic if your regulations contradict each other.
Well, I think she still could have testified. She may not have qualified as an expert witness in that hearing, but she still could have testified as a witness who provided the information within that report, and at that point, it could still be considered. And everything else in that report can be considered, even without her being there to testify. But she would not have qualified as an expert in the SORB hearing.
So she can testify as an expert, but not as a SORB expert. Is that how you interpret it?
Well, and she would just be a lay witness. She could
wouldn't be a
have
lay
been
witness.
a
She's a-
witness,
she's a
not a lay
doctor.
witness, but a witness to the information in her report and how she reached her opinions. But in order to qualify as an expert in sexual risk and recidivism for the hearings, they must be preparing a report. This report was also somewhat outdated as it wasn't prepared for this. But all the findings within it, other than any risk opinions, were considered. And I think counsel had mentioned that in there was other information regarding maturity and age and other discussions within the report, and those can be considered. It was any risk opinion in there that was the only thing that...
The new regulations, 2025, right? Mm-hmm. Do they address emerging adults in the way that the regulations address juveniles separately as to each factor, or is it?
Not emerging adults. I think they still address, each factor addresses adult versus a juvenile and how that factor is to be considered. I don't think there was any substantial change with regards to emerging adults, and I think part of the reason is the factors apply to juveniles or adults, whether they were convicted of an adult crime or a juvenile, is the distinction, and the courts and the legislature
But Dr.
define.
Quinones' report refers to substantial literature that says that emerging adults are not the same as adults. So is there any movement by SORB to consider that in its regulations?
There's certain factors that address when an offender commits an offense as a juvenile and goes on to continue to offend into adulthood, and how there's an actual factor that addresses that specifically.
So there's no movement towards having emerging adults be specifically addressed in the factors by the board, if you know?
No, not at this time.
Okay.
Surprised Dr. Hansen hasn't investigated this question yet. There's nothing
Specifically,
from Canada telling us what the research shows?
well, I think if you look at, even looking at some of the research, it's the maturity, it's more the maturity issue and how they have a lack of impulse control. And honestly, it's an issue where at that age, their risk to reoffend is higher because they're not thinking about the consequences and their actions, and that lack of impulse control. But in this case,
It shouldn't be that hard. I don't mean you would do it, but you'd think some scientists would have, grabbed the population of people who offended as emerging adults and see whether their recidivism rates were different than people who committed crimes as juveniles or committed crimes as adults. It's just a data.
well, there is, they've looked at those that offend as juveniles and go on to offend. And I think in this case, his only conviction was as an adult. There was sexual misconduct, which clearly didn't deter him from ultimately reoffending and getting the conviction as an adult, but he had some questionable actions as a child more than once, and then as an adult, even after being basically confronted, he went on to, his sex offense occurred as an adult. I think because of that, the board was kind of constricted to the adult offense, having those factors applied to the adult portion of it. Even putting the waiver issue aside and the juvenile brain, I think the burden here would have been on the offender to prove that he even had a right to an expert, or that he qualified for an expert in juvenile brain development. And everything at this point has only been speculation. And the courts have ruled that speculation without more really is not enough to find.
Well, it seems like there's a pretty good basis in the record for funds, potentially, right? Not just the fact that he was an emerging adult, but the report also refers to his cognitive deficits in conjunction with his immaturity. Wouldn't that, at least there's a reasonable probability that funds would have been allowed, don't you think?
Well, I don't think there's anything within the record that shows counsel went above and beyond the actions of a normal attorney in deciding whether to even ask for an expert. It's discretionary. It's not a mandatory.
Discretionary, but I don't know. I think an ordinary fallible attorney seeing that in the report would ask for funds.
I don't.
Wow, 21-year-old client classification, you don't see that a lot. Wouldn't that make an attorney think, what's special about this? Can I get an expert to opine about it?
I don't think there's anything special to him because he was 21. He was an adult. It doesn't make it special to him. We have offenders all the time in that age range. Just because they were 18 or 19 or 20 or 21 when they offended does not make them special, or a circumstance that is special to them that the hearing examiner can't determine on his own. These hearing examiners have been determined to be experts in this area. And, I think deference is owed to them. I don't think that Doe has shown substantial harm or change that would have been made by requesting a discretionary decision to request an expert in this case. I think if you look at the factors.
Your time has expired, but I did have one question. So, and sorry to belabor this point, but I'm looking at regulation 1.16 dealing with motions, all right? Subsection 5 is motion to reopen the record, which has to be made before the issuance of the final decision. So that route's no longer available to him.
Correct.
And then subsection 6, motion for reconsideration must be made before the expiration of the time for filing a complaint for judicial review. So that's not available to him. So there's no mechanism available to him, right, to go file an ineffective assistance claim before the board.
Not before the board, but that next option is the 30A. And I think,
30A,
which he did in this case.
No, I
what
mean,
counsel-
the 30A is not an evidentiary proceeding, as you know, right? So the problem is, we're here on direct appeal, so we don't have any evidence about what this report, expert opinion, might have said. You need evidence, so there has to be a mechanism to offer that evidence. But it doesn't look like, at least from the board's regulations, that the board would entertain a motion like that.
Correct. I think after aside from those two options which have passed, he took the path of.
And presumably,
I think the evidence is the report that was submitted.
presumably the counsel who's alleged to be ineffective would still be counsel during these time periods, right? So, you can't expect counsel to file something saying I was ineffective.
Correct.
Okay, well. Thanks very much. Thank you both. The case is submitted. We will take our break and be back in approximately 15 minutes.
All rise.
Okay, our next case is Michelle A. Thibodeau versus Joseph E. Thibodeau III, number 2025 P1427. This case is partially impounded, so please refrain from referring to private information.
Justice Shin, Ditkoff, Tan. My name is Sandy Derlin, Warner, Federico, and Ryan in Boston on behalf of the wife, who is the appellant in this appeal from a judgment which occurred after a long-term marriage, which had traditional trappings. Although both parties worked, it was a typical primary breadwinner, primary homemaker. And there are three components of the judgment that the Judge Ulwick, the trial judge, issued, which I'd like to address here today. The first and the largest issue is her treatment of the husband's public pension and his Chapter 32 pension, which, in all candor, I think has bedeviled a lot of attorneys, and in this case, I think tripped up the trial judge. Here, the judge ordered that option A be chosen, and option A under Chapter 32 provides the highest monthly allowance. It ends at death of the participant, and there are no survivor benefits. The judge seemed to link that choice, or contrasted that choice, with the other popular option, which is C, which is a slightly smaller monthly allowance, but it does provide a survivor's allowance. And that survivor's allowance is 2/3 of the participant's allowance at death. It's about 7 to 15% lower. The judge seemed to indicate that she chose A compared to C. Husband sought option A, being employed. The wife sought option C. The judge seemed to justify that choice on the lack of evidence regarding the present value of the pension interest and/or the survivor's benefit. But no evidence per se was necessary throughout the trial because both parties were seeking an equal division. And so the judge, although the judge looked at, or fixate is maybe a pejorative term, but she focused on that insurance link without sort of appreciating the fact that insurance is far more important with the option A choice.
Okay, so why, assuming we agree with that, why wouldn't your remedy just be a remand for additional findings? Because you're asking us to direct the judge to order the husband to choose option C. I don't see how we can do that.
Well, certainly a remand for further findings would be appropriate, but I think in this situation, you have the findings indicating that there is concern about the cost of insurance,
Yes.
which would emanate. The husband is a police officer. He's getting older. There could be significant premium costs. The insurance that he has now is provided to him as a perquisite of employment at no cost. The issue is the insurance component is necessary throughout the entirety of the payout under option A. It's only needed prior to the husband's retirement.
What is how can we direct the judge to order option C? That's what you're asking for us to do. Then you would have to show it was an error for the judge not to direct the husband to choose option C, and I don't see what the error is.
Well, I think the error is it's inconsistent with her findings about the wife's needs in this case, both her need for support, continued support through spousal payments, her need for continued medical insurance because of pre-existing health conditions and whatnot. Here, and so I think...
How is it inconsistent when she awarded the wife a disproportionate share of the marital assets?
Well,
You're saying the error is that it didn't take into account her needs,
it's,
but don't you then have to consider the rest of the property division?
well, I think you do, but in this situation, the judge has flipped the script. And so I think to answer your question, Justice Shin, I think the court, I think you have authority, the entire record is before you, I think you have the authority to direct her to and look at her findings, to indicate that the option C is the better choice, because this judge focused on the insurance component, which that's where the abuse of discretion occurred.
Is that the only relief you're asking for? You're not asking for a remand?
No, well, I mean, I think I'm asking for, well, my brief speaks for itself. I am asking for a clarification and a finding that the option C is more consistent with her findings and the evidence in this case, whereas option A is completely antithetical to the
thing is,
same.
your brief seems to specifically ask that we not remand. I mean, you say, in the interest of bringing proceedings to a reasonably quick end and minimizing any post-remand litigation, we should provide detailed directions to the trial judge. And so I
Right.
guess we're trying to get at, is that your position? You want us to go, change this and not remand, or do you want us to remand to the court to reconsider?
Well, I think, I would argue in the alternative, Your Honor. I do think that it would be useful, given the length of these proceedings, the trial proceedings, the length of the appellate proceedings, to bring a efficient and a quick resolution to this. A remand obviously is better than a dismissal, quite candidly, but I do think that there is sufficient information before this panel to make the order that I've requested. Certainly a remand is preferable to the alternative. But in this case, again, the insurance, the judge, she put misplaced emphasis on the insurance, because the interplay of insurance, life insurance security, with an option C choice, it's not at all what the judge seems to think it was. You really only need insurance until the husband retires. He intended to retire within 2 years. At that point, it goes into pay status. Both parties receive their share through the pension. No insurance is needed under option C because the wife has a survivor's benefit. Oddly, she chose A, did not order any life insurance at all, and option A requires life insurance, practically speaking, because there is no survivor's benefit.
Well, life insurance was required to the extent you can get it at little to no cost.
Right. That's a point I make at another section of my brief, but that amount of insurance is sort of general, it's a general provision. There's both the pension and the alimony component in this judgment. It's not directed to either one, and there's a step down every 2 years.
But doesn't that go to your failure to, not your failure, but your predecessor's failure to provide any evidence about the value of the pension?
No.
How's the judge supposed to figure out what the life insurance needs to be if no one tells the judge what the value of the pension is going to be?
Well, the $360,000 of insurance would be, it could be sufficient in this case, but for the fact that it appears to be linked to whether there's little to no cost, which provides the husband with effectively to make that decision himself subjectively. And it also, there's that step down that
I don't see why that's so. If the cost is $10 a month, and the husband says, that's not a little cost. Don't you think that he would lose trying to defend that when it was challenged in the probate court?
Well, I don't even, Your Honor, I'm not sure he could even be found in contempt.
No, he wouldn't be found maybe he wouldn't be found in contempt, but that's not the only way to challenge something. You could ask for modification.
It's the only way to
or
enforce the provision once the judgment is final. So, and in this case, you know, he is both on the life insurance and on the medical insurance. He's given the opportunity, I believe, under the language that the judge used.
I don't know why it would be the case that a divorce agreement or judgment can't be enforced unless it can be enforced by contempt. I don't know why that would be so. I don't know why you couldn't go into probate court and ask for an order ordering someone to comply with the agreement, or for a modification because he's not complying with the agreement.
Well, I'm not sure I agree with that, Your Honor. I mean, you know, enforcement is made through a contempt.
Well, why is that? Why is contempt the only way you can enforce a divorce
I mean, you
judgment?
could bring an action for breach of contract. Well, no, you couldn't in this case. Strike that, given a judgment.
Why couldn't you bring a modification?
Well, you could bring a modification but you'd have to show a change in circumstance.
Change circumstances, he's not paying the maintaining the life insurance.
That's a contempt. I mean, it's somewhat circular. And you can't enforce, you know, an unclear and unequivocal command in a contempt proceeding.
It's within the judge's discretion to order a payer spouse to maintain life insurance. Would you agree with that?
Yes.
Okay. So the factors that the judge considers include things such as cost of insurance, the policies carried during the marriage, age and insurability of the payor, right? And the judge said the parties offered no evidence about these factors. So what is the error? How do you expect the judge to order something when she doesn't have evidence?
She did order life insurance in this case.
Right. At little to no cost, because she has absolutely no evidence before her about what the cost would be.
But putting that aside, Your Honor, she also included a step down of $90,000 every 2 years, beginning this August, 2026. So over the next few years, that life insurance security will automatically reduce down to zero in 2034, when the pension could still be in pay status and with no survivor's benefit under the Option A order. So in this case, the error I suggest is the link to life insurance through Option C, when that could have easily been, it should have been linked to Option A. It's not. It's just a provision with an automatic reduction, which is inconsistent even with ordering Option A. So even if you assume that the judge was hamstrung by the lack of evidence, there was insurance in this situation, and the judge nevertheless still ordered a step down for reasons which appear to be linked to the durational length of the alimony in this case, because that will end in 8 years from the date of the judgment.
What's wrong with that?
What's wrong with that?
Yeah.
The step down?
Yeah.
The step down because
As it's
in
security for the alimony. So what's the
No,
error?
I don't challenge the any life insurance being linked to a durational period when the payments are obviously going to reduce. The problem is it's the only life insurance ordered in this case, and it's not linked to the pension.
Right, so your argument about life insurance is tied to your argument about the pension.
Yes, it is. They're linked, and I think that's the problem that the judge made. You know, I do believe that the provisions regarding the cost of life insurance and the cost of medical insurance being through his employer at little to no cost or reasonable cost, I think are problematic, because in this case, the husband was clear. He didn't want to provide health insurance. He wanted.
The statute itself says reasonable cost. for health insurance, right?
I'm generalizing.
No,
Reasonable.
you're saying
I
that
believe
reasonable cost is,
Reasonable cost was medical insurance.
right, and you're saying that's improper, but that's what the statute says is reasonable cost.
Right, but in this case, the husband estimated his cost, I think at $85 a week on the high end, $80 to $85 a week. My argument was that should have been the baseline. That's what the judge should have found, so
Did
that,
find
again,
that. She
we
said
have a clear
reasonable cost.
directive.
She said reasonable cost is assumed to be around $85 a week.
Well, that's not what the judgment said, though.
I mean, that's what the findings say.
Well,
Right.
okay, I mean,
Let me ask you, since your time's up, you've briefed the accrued leave as if the TO, sick time, personal time, and admin time are all can all be cashed out, but I didn't see any evidence of that anywhere. Am I missing something?
evidence of being cashed out.
Yeah, you can cash those things out. I know you can cash out vacation time, that's in the statute, but you briefed it as if all that other time could be
Well,
cashed
I mean,
out. I didn't see
you're
any
right.
evidence.
That is true. The evidence was thin, but it did show the amount of the accrued benefit. And the husband is paid on an hourly basis based on his or the union contract through the police department. So I think you can assume, or reasonably, the trial judge could have reasonably assumed that that would be cashed out in some way.
Why? Why would you assume that? That's not how it works for normal people.
Well, it is how it works, as Your Honor pointed out, in terms of,
Vacation,
in
sure.
terms of the statute.
The statute says vacation, but most people don't get any sick time, personal time, admin time, or whatever TO is when they retire or quit.
But it was not addressed at all in the findings anywhere, or in the judgment anywhere. And my point was, to the extent that it represents a significant amount of money, it's either income and or an asset which could have been divided if and when received. That was my point on that. Right. So the amount per se would not matter.
All right. Thank you very much.
All right.
May it please the court, I'm Robin Honig. I represent the appellee Joseph THIBODEAU. And I request that, based on the briefs and the oral argument, that the judgment below is affirmed. You basically have said my part of the argument. I'll start with this being a frivolous appeal. The judge made a 49-page findings of fact, rulings of law memo. She did an amended judgment of divorce, and it was extensive. There was no abuse of discretion. There was no error of law. She considered all her broad discretion rights under MGLC 208-34. And based on that, I believe this appeal is just like a revenge appeal to keep prolonging the divorce case. My client's assets and the marital assets have been frozen since the divorce started. He is a lieutenant in the police force, and since...
All right, so the judge wrote, the reason why she decided on option A is because the cost of any such life insurance husband would need to obtain to secure wife survivor benefits under option C was not established, and it is more likely than not husband would incur an increased premium for such life insurance. Now, considering that you don't need life insurance at all when it's option C, why is that argument frivolous, that was incorrect?
I think, as you stated previously when my brother was speaking, the judge looked at the whole case, and she divided all the retirement assets 50-50, which is what she did by choosing option A of the public employee pension. If she had chosen option C, if the wife had remarried before my client retires, she loses all retirement benefits. She can't be remarried at the time he retires for option C to kick in. Also, there could be a lapse. Say my client stopped working. He's still paying alimony, but the retirement hasn't kicked in. There could be a need for life insurance between that gap time. But the wife's attorney below never produced any evidence about what the life insurance would be, what the amount, and I think that's what Judge Elwick was saying.
Since you definitely need life insurance for option A, it seems to me very strange that the judge said, I can't figure out the life insurance, so therefore I'm going with A. That seems exactly backwards. It's A where you need to have good life insurance. C, maybe you need a little for the gap period, but then you don't have to worry about it once we get to retirement. So how is that not an abuse of discretion? That reasoning, regardless of whether the other stuff is okay.
Because she looked at the big picture, and option A gives each party 50% of the monthly benefit versus option C gives 7 to 15% less of a monthly benefit. None of the retirements that were divided have life insurance to enforce if somebody dies for the retirements. All the retirements were divided 50-50.
Were any other retirements such that you lost everything when someone died?
I don't believe so.
So you wouldn't need life insurance for ones that don't have that aspect, unlike a police officer or pension I'll have someday.
Correct. And she does, in what you were stating before, there is life insurance provision for the alimony component, but it also states if my client doesn't have life insurance option through his employer, he has to obtain life insurance with a $360,000 value as well. It's not just through his employer. I believe that the judge had looked at the entire case and looked at all the assets and felt that option A was the most fair, considering that my client, when he retires, he still could be paying alimony. The wife in the division of assets got 55% of the home values, so she is receiving $499,000.
I mean, it might be more fair, but what do we do when the judge gives a reason that doesn't seem to be supportable?
Because I think her reason was that gap time, either if the wife remarries or there's a gap in time before the pension kicks in. My client is still paying alimony, but there is a chance that...
Where can we find in the decision or somewhere that that was what the judge was focused on, is the gap time?
It's in her findings of... in the judge's findings, they're in Volume 1, page 205, paragraph 153 and 154.
But that doesn't say anything about the gap time. I mean, you might be right, but how do we infer that from what she wrote?
I just think because of her 49-page findings, it went over every issue. And she was concerned about the parties' finances, my client having to pay the alimony while he could still be retired, but he's still paying alimony until he's 67. The wife did obtain 55% of the assets. It's just so much money that can be done. So by doing option A, it gives each party the full benefit of the pension's monthly payment.
As long as she survives him.
Correct.
But not if she doesn't, right?
Right.
Was there evidence that she was planning on getting remarried? I didn't see that.
No, there was no evidence of that, but there's a possibility. So in the judge's mind, perhaps she was thinking of the whole picture and what was fair for everybody. And as far as the other issues with and again, and she did emphasize how the wife didn't submit any evidence as to what the benefit values would be on the pension or life insurance. So there's no evidence. And she stated, the judge stated in her findings, she thought because of that, it was reasonable for her to order option A. But regarding the PTO, sick, and vacation pay, there were two pre-admitted exhibits in Volume 5, pages 441 and 444, that one, Exhibit 50, states some pay time from 2021 to 2022, and page 51 has no dates, and nothing was mentioned at trial about using PTO, sick, or vacation pay. No prior alimony order used those amounts. So that, again, is just a subsequent thing that was done after the trial. In fact, it wasn't even in the wife's proposed judgment. It was in her proposed judgment to amend the judgment that she decided to add that to it.
But the thing at Record 134 wasn't the pre-judgment proposed judgment?
134. Did you, excuse me?
So on Appendix 1, page 34, the proposed judgment has 25% of the pay received for unused paid time off, sick time, and vacation time. And I thought that was pre-original judgment.
Her proposed judgment, it must have been her proposed findings. And her amended judgment definitely said it in Volume 1, page 266.
Well, the proposed findings that are
I think it was her
144 also refer to this issue.
It wasn't brought up at trial, and it had never been used in prior alimony orders, and there's no evidence that those things even existed in September of 2023 when the trial occurred. Sick pay under the Massachusetts Wage Act isn't considered a wage, so that wouldn't be used in an alimony calculation. And there's no evidence that there's no evidence of my client's employment contract in the case, and there's no evidence that there is even a value to any sick or vacation pay, or if it even existed. My client
Well, but
used it.
as a matter of law, anyone is entitled to cash out unused vacation time when they retire or quit, right?
If they have it in their employment contract.
Period, right? If you've got accrued vacation time under the Wage Act, you get paid out on that when your employment ends.
If you have that, correct. But there's no proof that he didn't use his vacation time before September of 2023, so there's no value. And as far as the health and life insurance, the appellant claims that the terms were ambiguous, undefined, and unenforceable. Aside from the pension issue, the health insurance, as Justice Shin said, the judge below said as long as it's a reasonable cost, and she cited, for example, $85 a week.
So can I ask you, though, it says, the judgment says, husband shall maintain coverage so long as it is available to him through his employer at a reasonable cost. Is it your position that the obligation terminates at retirement or not?
No, because he's a public employee, so according to the town, they pay the supplement, because if, say, he goes on Medicaid, the wife is still covered under the town's insurance because it's a public employee. And if he remarried, she would have to go under COBRA.
So, I mean, in the Weiss brief, she says it's ambiguous whether employer means after post-retirement, and I thought your brief would address it, but it didn't. So you're saying today that, in fact, the obligation does continue?
It does continue if the employer
Post-retirement.
provides it for an ex-spouse.
But what does employer mean? So once he retires, does the obligation continue or not?
It continues.
Continues.
It's the town of North Reading.
Okay,
It's technically the employer.
thank you.
So as far as that in the appeal, I don't see any ambiguity, undefined terms, or if it's enforceable, because as long as it's available and the town provides it for an ex-spouse, again, if my client remarried, she technically would have to go under COBRA, and then there's a question, what is the cost of that? But my client is paying it as long as it's a reasonable cost. And like you said before, perhaps then it has to be a modification if the numbers change for the payment amount. So basically, other than the question about your pension, and I believe that the judge just looked at the testimony, the evidence she had from the two-day trial, and considered all the witnesses and the facts and just made a reasonable decision. And I request that the court affirm the judgment below.
Okay, thank you very much. Thank you both. The case is submitted. Our last case is Department of Children and Families and Another versus the Mother, case number 2025 P1162. And I'm sure, as all of you know, this case is impounded, so please do not use any names.
May it please the court, I'm attorney Catherine Foster. I represent the mother in this matter. And the question I have today is, when is it an abuse of discretion for the trial court to substitute its own judgment over experts with direct contemporaneous observations that contradict the court's conclusions? And specifically in the areas of housing, medication misuse, alcohol abuse, and the child's need for therapy. In the case of housing, the court relied heavily on mother's instability to find mother unfit. But in 2023 and 2024, mother obtained an apartment for 10 months. Mother was in an apartment in 2023 until after the child was removed. On February 1st, 2024, with the help of other agencies, she obtained an apartment that would have had space for the child and remained there through the time the judge issued their findings in July 2025, but the judge only gave credit for 5 months.
So can I ask, you mentioned February 2024, right? But also in February 2024, wasn't the mother involved in a police chase with her boyfriend and then was not forthcoming about it, and then subsequently had some missed visits? So my point in raising that is that during the same time of the housing issue that you're raising, there were a lot of other issues going on, correct? Which I suspect opposing counsel is going to argue, and they have argued, that the judge didn't really rest necessarily. It was not just a housing issue, right? There was domestic violence, there was alcohol abuse, and so there were other factors that the judge found, correct, in making the decision for first of finding him in fitness, and also that it was in the child's best interest to terminate.
There were other things going on, you're right, Your Honor. But I guess my argument rests on, a judge is allowed to consider a constellation of factors in finding a parent unfit. But, when, for lack of a better metaphor, when some of those stars can't stay in the sky, at what level does the evidence continue to rise to the level of clear and convincing evidence to support parental termination?
So are you arguing that there was insufficient evidence without the housing insufficiency, housing instability, and the misuse of medications? Is that the argument? Are you arguing that it affected her decision?
I'm arguing that the court's decision is undermined by the fact that it included as bases for finding the mother unfit inaccurate conclusions that contradicted the contemporaneous observations of people at the time. For instance, with regard to medication misuse, prior to 2024, it's possible that mother misused medications. But in 2024, the social worker testified on the stand that although DCF had a concern about mother misusing medications, the social worker who was viewing her medications and counting them monthly had no concern that mother was misusing her medication. And the psychiatrist—
Why does the judge have to accept a DCF social worker's opinion?
Well, I would argue that if the department is saying a generalized concern, but then has no proof to support the generalized concern, and indeed also mother's psychiatrist had no concern, I believe the quote is, she was not drug seeking. And they were continuing to follow up with her prescribing psychiatrist.
When there's testimony that she was double filling prescriptions at some point in December 2024, or November 2024, there were too many pills to even count, and that she admitted to the social worker that she had a drug problem. Why isn't that evidence to support this, regardless of whether the social worker's opinion is?
Well, specifically with regard to that, that was at the same time that the social worker did not think she was drug seeking, and because mother had transitioned between psychiatrists or programs, and they were both prescribing. So I think it weighs against the judge's finding, because mother was very forthcoming with the social worker, even though the judge found her not credible on the stand. She showed the social worker all of the medications. The social worker directed her how to correct the problem of both practices, filling her prescriptions, and the next month she had the right number of pills, and the social worker was able to see and count them. That is just, it just doesn't support that she was misusing medications when the prescribing psychiatrist and the social worker who were there to see and knew mother didn't think that was the case. And I guess it also goes to when the trial court finds a parent less than credible and less than forthcoming, and mother certainly had struggled here, how much extra weight does that credibility determination have in the judge's findings? I mean, can it add to, can the credibility determination support that finding? Can the credibility determination somehow support the finding that mother had only been in her apartment for 5 months when by the time she asserted her findings, it was 18 months? And I would say no, but in this case, it feels like...
I don't know why 18 months matters. Doesn't the judge have to find whether the mother was fit at the end of the trial?
Yeah, well, okay, so current
I get the
fitness,
5.
unfitness-
I get the 5 is too low. I mean, but
Yeah.
but I don't see why we get to 18 because he doesn't know what happened. For all he knows, the day after trial, I know this didn't happen, but mother moved out or, got evicted.
Well, so then, do we believe what the judge says in their findings in that instance when they say that the mother had lived there that long, or is that harmless error, but the, other errors are not harmless?
All right, I mean, that is the question. The 5 is definitely wrong, so how prejudicial is it? How likely is that to have changed the judge's decision if he had known, if he had gotten the correct number?
Well, and
I would like you to tell me why I should find that was prejudicial.
Because I think that the judge found mother unfit based on her lack of credibility on the stand. And I think that the judge's decision would carry more weight if the judge had focused on the reasons that the judge thought mother was unfit that were more supported by the factual record, instead of kind of, throwing stars up into the sky, as it were.
So in that regard, I would think that I'd figure out what the judge's focus is from the summary. And I didn't see anything, maybe I missed it, about the housing instability or the medication, plenty about alcohol use, the medication misuse in the summary didn't really seem to be a focus or really even, am I missing something or am I analyzing it incorrectly by looking at the summary to figure out what mattered to the judge?
No, I don't think that's inaccurate, Your Honor. Yeah, a lot of the summary has to do with the judge's finding of mother's credibility, and the conclusions focus more on the housing instability, the medication misuse, alcohol, and the child's need for therapy, which the department only got therapy for the child after the department reduced visits with mother, and the child began to exhibit behavioral dysregulation. So what the judge also says that the child, one of the reasons mother was unfit was because the child entered care needing therapy, but DCF didn't seem to think so and did not seek therapy until after DCF reduced the mother's visits with the child and the child acted out.
But we don't know the causation, right? Was there any evidence of I understand your argument that I think you're making, which is that there's an inference that the child was acting out because the visits were reduced.
I think there is information that the foster parent reported the child was upset after what happened was mother missed 2 visits after the department reduced visits for the second time, and also put into place this system that required mother to confirm the evening before and the morning of. And I think, mother missed, it took mother a couple months to realize she had to do both, and within a certain time frame. One time she confirmed the morning of, and I think it was after 10 o'clock a.m., so she wasn't allowed to visit. So it was during that time that in late 2024 that the child became upset, and I think she was did some acting out in school, and the foster mother reported that to DCF, and I believe that's when there's a court, the October 11th, 2024 court report indicates that the child started therapy.
So you say that she was living in her apartment for 12 months by the time trial ended?
Yes.
But the judge found that at the home visit in February, late February 2024, that the apartment wasn't furnished, it just had an air mattress. And then the conclusion of law that you challenged says she had been residing in the apartment for approximately 5 months. So how do you get 12 months?
Because mother, I mean, she was poor, but the DCF doesn't remove for poverty, so if she had very little furnishings.
Right, but why couldn't the judge find she wasn't actually living there in February, because there was only an air mattress in there? There was nothing else in there.
I mean, why wouldn't the judge find she was living in her apartment? I guess that to me is reflective of poverty, not residence. And I mean, she did obtain that apartment on her own, and that was her residence.
I mean, the judge acknowledged that she had obtained an apartment in February, right, in the findings. So the conclusion, I'm not sure exactly where the 5 months is coming from, but why isn't it harmless in light of the findings that do acknowledge that she got the apartment in February?
I think it's not harmless because the cumulative effect of the errors that the judge made with regard to the housing, with regard to finding mother was currently misusing medication, to finding things like mother didn't immediately report her relapse in July 2024, when she did report it to the social worker at their next meeting.
Isn't the relapse itself significant, though, just months before trial with her history of struggles with sobriety? I know you focused your argument on housing and the medication, but that's a fair concern, right, the judge and would support?
I think that it would be more concerning if there was evidence that at the incidents previously that the child was present or impacted. So there were incidents, once a year, basically, mother had an incident with alcohol. You could tell when she was using alcohol because something happened. In 2021, she was arrested. In 2022, she had a seizure. And then July 2024, her friend was shot and killed, and she had a relapse based on that instance. But in none of those situations was the child present. Mother had created created family of support with the foster mother's daughter, her own mother, and she did share care of the child with these people so that when she was in situations that were inappropriate for the child, that the child was not present typically. And I see my time is running out, so.
You have 47 seconds. If you'd like to say anything else.
So I would, on mother's behalf, ask that you remand for the issue of fitness, but also for the issue of best interests, because what the child expressed that she wanted at the time of trial was to be able to continue in the created family that mother had set up for her as a support system, with mother as a key part of it. And
Okay,
thank you, Your Honors.
We'll hear from attorney for DCF. I understand you're splitting your time evenly, 7.5 each?
Yes, Your Honor.
Okay, thank you.
Good afternoon. May it please the Court. Matthew Price on behalf of the Department of Children and Families. The Department is asking this Court to affirm the decision of the lower court that terminated mother's parental rights. The trial court's decision was the correct one, and it was not an abuse of discretion to terminate the parental rights. The record supported the judge's decision that mother was unfit and that unfitness was likely to continue. Mother was in an unfortunate situation where she was dealing with a number of different issues, and I think this case captures the description of dealing with a constellation of factors that amounted to unfitness. This did not hinge on one specific thing or even two specific things. Mother was dealing with alcohol abuse, domestic violence, substance misuse, housing instability, and mental health issues. While she did engage in some services, the judge found that they did not produce observable changes that would warrant returning the child because the child would go back to potentially still harmful, risky situation. The behaviors that continued through 2024 included, although Mother began the year in therapy, therapy stopped in April. She was involved in a car chase with her boyfriend in February. She arrived to visits with the child with bruises in March. She relapsed in July. And in December, around the time of when the trial started, there was a finding that describes prescription medication that couldn't be accounted for, which fit a pattern that had lasted over a number of years. So,
Counsel, the trial judge, like you, does a pretty good job of explaining why Mother's unfit and why Mother can't have custody. But I didn't really find any explanation on why termination was in the best interest of the child here when both resources being considered are well known to the mother, one her mother and the other the family friend. So A, why is it in best interest to terminate? And B, how do we tease that out from the judge's findings?
well, where the judge finds that the unfitness is likely to continue, and I think that there was sufficient evidence of that, the judge can terminate the parental rights.
Only if it's in the best interest of the child, right?
Yes. And
why is it in the best interest of the child to terminate? And accepting that she's indefinitely unfit, why is it in the best interest of the child to terminate her parental rights?
because there's no evidence that the unfitness will end, so mother would not be a likely candidate for the child to return to live with. It frees the child for adoption or to move on in her life in a more stable circumstance. It didn't, this didn't cut mother out of the child's life. The judge recognized that there was a bond between the parent and the child, and that's why they issued
So what's the evidence that the mother's involvement as a parent is harmful to the child's current situation? I understand there's problems with the visits, but of course the judge continues those. I mean, so what's the evidence that her having parental rights is interfering with the child being with the family friend or being with the mother, the grandmother?
It frees the child for potential adoption to move on in her life in a stable situation. If not, mother continues to be unfit. She continues to be able to bring forward, for example, a review and redetermination for consideration if the judge doesn't terminate the rights indefinitely. And the judge found that...
Well, why is the risk of a mother moving for review and redetermination while she's still unfit something that's harmful to the child? I don't get that. You said that the harm would be that she could move for redetermination. Why would that harm the child?
No, I don't mean that that would harm the child. I mean that that is something that could take place indefinitely that would keep the child from moving forward in a stable placement like an adoption.
But isn't the stable placement here being placed hopefully with the family friend that's been going on for months? Why does termination help that? It seems to have already happened and seems to be continuing.
It solidifies that, is how I see it, that there's not, that relationship is not going to be interrupted moving forward, and it's going to allow the child to develop in this safe, nurturing circumstance.
Are you saying basically that by terminating the mother's rights, she will no longer have the ability to come back, every 6 months to file a review and redetermination that could potentially disrupt her permanency plan with the current placement? Is that what you're arguing?
Yes.
If she did, in fact, she did obtain an apartment, and if she was, in fact, living there for a year, that's significant, right? A year is that's significant.
Well, the judge made findings that she did obtain an apartment in February.
But then in the conclusions, he says she'd been living there approximately 5 months.
Because that's when she presented a lease.
Right, but...
That's where that came from. But
she had a home visit in February, so she plainly had an apartment before August.
Yep, and I think the judge acknowledged that. And considering that over a much longer period of homelessness, it was, I think, within the judge's discretion to consider.
A year is a long time, right? It's significant. If she had been living there for a year, she had the apartment before she presented the lease. So, the judge found she presented the lease in August, but she had the apartment before that because there was a home visit in February, right?
That was his finding.
So, a year is significant. And so where the housing instability features in several of the conclusions, why isn't that error?
It's not error because he's weighing it against a much longer period of time where she was homeless or had housing instability.
A year is not significant enough in your view.
In the judge's view, which I think is reasonable.
Well, he said 5 months, so.
If you gave the 12 months, I think that it's the same answer. It's inconsequential, given the larger picture and the longer period of time that she was homeless or had housing instability.
Okay, thanks very much.
Good afternoon, Justices. Beth Nussbaum for the child. I'm so sorry. I should have taken water.
Mr. Price, could you give some water to your...
Please, thank you. I'd like to continue answering the question, Justice Shin, that you posed to my brother. It's not clear whether the judge erred or not in terms of housing instability. Thank you so much. Let's assume that the judge did err. Let's assume that mom was actually living there from February and that she demonstrated 12 months of stability. This case does not rise or fall on mother's living situation. There's something much more fundamental that my sister simply didn't address, and which is mother's inability to take care of herself. Mother could not take, and this also answers Justice Ditkoff's question. Mother was not able to take care of herself. She couldn't protect herself. If she couldn't protect herself, it is highly likely that she would not be able to protect her young child as well. Throughout the life of the case, mother was battered by various people. She came to visits. She had broken ribs. She had a concussion. And these are not all at the same time. This is over the life of the case. A concussion, broken ribs, a black eye, being in a car during a high-speed car chase with a boyfriend who had an altercation so violent with his father that the child was present and had to be shut in either a closet or a small room. Finally, in only a month before trial, or actually I can't recall, it might have been just a few days before, no, it was in October, so a month before trial, mother was stabbed in the abdomen So there were a series of really violent episodes, not to mention mom's own earlier criminality, which was very long, very tied with her mental health and her alcohol issues. Look, clearly this young mother had a horrific childhood herself. And I think that she needs to be credited for the efforts that she clearly made on her own to try and get sober, to try and get a stable living situation. But it wasn't enough. She rejected help. She called it crap and BS. She said that, why should I go to therapy? And this was in December of 2025, well into trial. Why should I go to therapy if I won't get credit for it? As if it was a game. So it seems that because she was so failed as a child, that she simply rejected any and all help offered and thought she could tough things out and get better on her own. And to some extent, it appears maybe she was getting a little bit better, but clearly not better enough if she continued to be assaulted through, and I'm not saying that was mother's fault, but she didn't take serious measures to prevent it from happening again and again and again. How can she protect a child when she's in that situation herself? The child did say that she wanted to stay with her foster family forever and ever. This was practically a kinship placement. This was a close family friends. And while, sure, it could be argued that they were adequate substitute caretakers such that permanency through adoption maybe wouldn't have been required, but it was required. And that was revealed through child's psychological state when she made statements to workers and the foster mother that she was afraid somebody was going to come get her from school and take her away. So Justice Ditkoff, to answer your question, there was a real harm to the child and her lack of permanency. She wanted home. She wanted stable parents. And because mom was so resistant to treatment, that wasn't in the offing. It just wasn't. And the judge recognized that mom was good to the child when she visited. I think the judge may have erred about the housing, but the judge certainly didn't err. The judge credited mom where mom was due in terms of the appropriateness of the visitation and gave mom 4 visits a year because of that.
The goal is adoption with the
Yes.
placement, and at the time of trial, it appeared that the department was exploring a plan to approve that family, correct?
Yes, Your Honor, that is correct. And so I think that despite the judge's misstep, which looks like it may have been a misstep, I mean, it's arguable. Justice Shin, you questioned whether only having a mattress is indicative that somebody's not really living there. I mean, in mother's defense, there are poor people who live that way for months on end.
She was looking for furniture through.
Exactly, but I don't think that's material. I just don't. There's too much else in this case that militated in favor of mother's unfitness, and that termination was in child's best interest. So if the court doesn't have any further questions.
Okay, I don't see any. Thank you very much. Thank you all. The case is submitted. That concludes our sitting. Thank you very much to the court officers and our clerk's office and our timekeeper. We are adjourned.